on the wetlands piece.
Yes.
One is, I understand that the intent is to sort of align the definition with federal. Are there lands now that are being protected as wetlands that will no longer have wetland protections?
I'm not exactly sure I can answer that question, but I can find out and get you the answer. I'm not aware of any that I've been made aware of. So, but there could be. There could very well be some, but I'm not aware of any at this moment.
Okay. Follow up, please. Follow up. Thank you. And the concern I have is if we are kind of giving over control of what's defined as wetlands to the federal government, it sounds like those definitions change periodically. Do we lose some of our land management capabilities if we kind of strip ourselves of that capacity?
I understand your concern, but I think since it's only been just a few years, I don't think there's been a lot of reclassification because the federal law has been sort of tied up in the court system, and so I don't think there's been any added that I'm aware of.
Okay, thank you.
You're welcome. But if there is, I will certainly let you know.
I appreciate that.
Senator Woodard.
Thank you, Madam Chair. Senator Jackson, I guess I'm going to ask you to look into your crystal ball because you're in touch with a lot of this a little more than I am. Can you tell us what the current status of federal litigation is on this? And do you have any prediction of what might happen in the next couple of years? Because this is written, I think, with the anticipation that there might be some resolution to some of the legal matters, I think.
Well, in my crystal ball vision, I see it being resolved, in the Supreme Court when it comes as favorable to the previous rules that we're trying to adopt here.
So that we would follow up.
We would follow into the federal.
We'd
all be together.
We would revert to the 2019, was it?
That's
rules?
correct.
That's your prediction of what you think we're doing.
Out of crystal balls.
So this is kind of anticipating that that's what'll happen, and we'll be in line with 2019 federal rules.
Now, the staff have
Is that right?
Cal looks like he's just dying to say something.
Madam Chair, may I respond?
Of course. Sorry, go ahead.
Kyle Evans, legislative analysis. Senator Jackson, that's right. I did my homework on this, so I did want to speak up a bit. So, Senator Woodard, to answer your question, the Biden administration has promulgated its WOTUS rule, which effectively restores the pre-2015 regime, where any waters that are either have relative permanence or significant nexus are considered waters of the state. So the Biden administration's rule is currently in effect in 24 states, including North Carolina. Sackett versus Environmental Protection Agency is currently before the Supreme Court. I think they've already had their arguments. And crystal ball, potentially, we're going to hear that, or that opinion will be released this spring, and will let us know kind of what is going on with the other 26 states where the Biden administration WOTUS rule is currently not in effect. But for North Carolina, we are under the Biden WOTUS rule, which is the pre-2015 Rapinos decision, if that clears it up or makes it even muddier.
Okay.
And I'm happy to talk offline about this as well, with anybody if needed.
Maybe I don't want to take the committee's time. I may follow up just to make sure, because I'm not sure what the timing is.
Right.
But I think, final question, Madam Chair, if I could. The intent, Senator Jackson, is to make sure that we go back to those pre-2015 rules. Is that right?
Not really. It's mainly to make whatever ends up being the federal rule, will be what we will be.
Oh, okay.
So we will not have two different sets.
So whatever the May or June
ends up
ruling is from the federal Supreme Court, this just says we'd be in line with that. We would not do anything beyond that or less than that. We would just be in line with whatever the federal determination is.
That is my understanding.
Okay, that's helpful. Thank you.
Yes, sir.
Further questions from the committee members? If not, we have a couple people signed up to speak. And the first name on the list is Lou Starling. And I understand he is the mayor of Clinton, but you can state your name for us.
Lou Starling with the city of Clinton. I have with me the city manager, Mr. J.P. Duncan, and the police chief, Mr. Anthony Davis. And thank you for your service, and we're very proud of our senator, Senator Jackson. Although he lives a little bit down the street from Clinton. If we had annexation, we could bring him in. He wouldn't like that.
That's not gonna happen.
Word.
I wanted to see if you were still awake. I come to you to say thank you for all that you do, but to bring to you a very serious problem that we're experiencing. We're very proud of our heritage with the agriculture industry, with swine, chickens, turkeys, but we have a problem that in the city that is other cities are experiencing as well, and that is spillage on the roadway. And unfortunately, we have had 22 spills within the city limits of Clemson. 22. And 22 in the city of Clemson. This is across the street from a nursery, across the street from our automobile dealer, and across the street from community college. And under the current law, when we started finding out about this awful situation that was getting worse, we found out that in my mind, there's sort of a loophole in the law, because all our police could charge these people with, number one, if they stayed at the scene, was a $50 civil penalty. So we're out there with 4 police, 4 or 5 fire trucks and Public Works and or DOT, and we're there all day long taking it away from other citizens. And the only thing we could do is a $50 civil penalty. We couldn't even make them fix it, to make them clean it up. And then I'd say over half of these folks drive away and we can't find them. Or if we do find them, we can only charge them with a $50 civil penalty. And I thank Senator Jackson for this draft, that this appears in my mind to help with the drive-off situation, that it gives us some crime to charge, number one, and number two, and very important, it lets us charge back these drivers for the cost. But there's still, in my mind, a hole that we need to fill, and that is, if this occurs, there's got to be more, in my judgment, than a $50 non-binding civil penalty. When our fire and police, we don't have but 4 police at the time, 4 fire at the time, 4 public works. All our people are there all day long, and the overworked DOT workers are out there cleaning it up as well, and we have no vehicle to make them pay or do more than a $50 penalty. So I would urge you, and I think speak for other municipalities and for the DOT, I think I would, that has had to clean this up, that this is a very, very serious problem, and I appreciate your amendment, but I would ask you also to look at this 2116, that if this occurs, there's got to be more than a $50 fine. It needs to be something that the person would have to go to court with and get cost of what to clean up. And I thank you for I'll be happy to take a question, but I thank you for your time, and Senator Jackson for his work.
Thank you. Our next speaker is Keith West.
Good morning, Senators. I'm Keith West, Deputy Director for the North Carolina Veterinary Medical Board. The board respectfully requests that you amend the North Carolina Farm Act of 2023 by removing amend veterinary medical board inspection process located on page 3, lines 26 through 38. Language identical to this has already been approved by the North Carolina Senate with Senate Bill 282. The board believes inclusion of this amendment would restrict the board's ability to fulfill our mission to protect the people and animals of this state. Currently, routine inspections are announced and scheduled in advance. The board needs the ability to conduct unannounced inspections to react immediately to credible information that indicates a potential risk to the health and safety of the public. The board is confused as to why the ability to conduct unannounced inspection is being taken away. Other facilities such as hospitals, nursing homes, pharmacies, and boarding facilities all undergo unannounced inspections. Do the elected officials of the state want one of their constituents, whether it be a pet owner or an employee of a veterinary facility, to call the board with a credible and immediate concern to be told, due to legislation passed by the North Carolina General Assembly, we must contact the veterinarian in writing and schedule an inspection at least 7 days in advance? And if that is not convenient for the veterinarian would have the option to reschedule the inspection the following week. That would be the result if the proposed amendment were to remain in the proposed legislation. The board is available to meet at any place and any time to discuss our concerns. Thank you for your time and consideration.
Thank you, Mr. West. Are there any further comments or questions for Senator Jackson on the Farm Act? And just a reminder, this is for discussion only, and we will take a vote tomorrow. So come back
I
tomorrow.
got one comment.
Okay?
Thank you, Madam Chairman. And members, that is correct. We will vote this out tomorrow morning, somewhere after 9 o'clock when we meet again. I appreciate all those that came and spoke this morning. And I would just happen to say to Mayor Starling, and I told him this after I learned of this, I actually accidentally drove up behind that spill there he's talking about at the community college, and it went for a quarter of a mile, basically. This is not just this was a big spill. And so that's prompted me to get involved with him and trying let's get something done on that. So thank y'all for listening. Any other questions?
Senator Woodard.
Well, to that point, I'm sorry Senator Garrett's not here today. He and I filed a bill, and I think we'd be happy to share it with you, Senator Jackson, anyone else who wants to talk about spillage of from garbage trucks and other agricultural vehicles. So,
Okay.
at least
I'll be glad to talk with you.
It's a place to start anyway.
Okay. Thank you. Thank you, members.
Thank you. We will go at this time to Senate Bill 515, Water and Sewer Affordability Act. Senator Sawyer.
Yeah, thank you. Yeah, yes, we do have an amendment. Yes, ma'am. Yeah, Senator Jarvis. Yes. Go ahead.
There is an amendment. You should have that before you, and Senator Jarvis moves to amend the bill. He was explaining it.
Thank you. Go ahead, Senator.
Go ahead, Senator Sawyer. You want to talk to the amendment?
Yes, thank you. In classic style, I go to Senator Jarvis right before the meeting, and I said, Senator Jarvis, please amend my bill. So forgive me for that. But so we had meetings with some stakeholders yesterday in regards to the cap of 75%, and hearing their concerns. This amendment addresses that, and so I would ask the committee's support on this amendment to the bill.
Are there any questions on the amendment? If not, all those in favor, say aye. Any opposed, no? Okay, we're back to the bill. Amendment passed.
Thank you so much. I can promise you in the off season, I did not sit around thinking about water and sewer rates until my constituents asked me to do so. So that's where this bill came from. And I want to thank Jenny Covington and Senator Perry and Lazzara for helping me with this bill, along with the Utilities Commission. Really, it's just a playbook on how utilities, private utilities especially, should work in North Carolina. The first one, it does give the utility commissions 30 extra days to review the multi-year rate cases. Those of you who were here a couple years ago, remember when we allowed them to do multi-year rate cases, the commission asked for 30 extra days to hear those. The second section of the bill is just a playbook on if you're going to privatize your municipal water system, how you should do it. It's just transparency, guys. Just know how this is going to happen, and that when you do sell your utility, that you should return that money or invest it back to the ratepayers or to any bonding agencies that you borrowed the money from in the first place. The last part of the section, that was what was just amended. It talks about the ability for a municipality to charge rates to folks outside of their municipal borders. That, you can imagine, has been the point of a lot of great conversation, even amongst the bill sponsors. And this is the part we're still going to continue to work on, and I hope the amendment addressed those concerns. And I turn over to Senator Perry for any further comments.
Senator Perry.
Thank you, Madam Chair. The amendment just clarified what was already there. It wasn't really a limit. It just said if you go over that limit, you've got to have a public hearing and inform the consumer. That's pretty reasonable. As we've had changes throughout the state, you've had some water bills spike, as you would expect. Consumers been surprised, didn't know why, didn't know what was going on. So we just want to clarify that we want to protect the consumer. We want to inform the citizens in our state when we have these changes. The sections about selling your water system doesn't say you can't sell it. So you've got to be transparent about the sale and what's going on, and you must use those proceeds from that enterprise fund. Remember, we're not talking about tax dollars. Utilities are funded with an enterprise fund. You've got to satisfy the debts that were put there because of that utility and that enterprise fund. It's just good fiscal common sense. It's being responsible. It does not hamstring and say you can't. It doesn't say you can't charge rates. It just says you have to communicate and be transparent about it. So happy to answer any questions.
Questions from the committee? Senator Woodard.
A comment more than a question. I want to appreciate the sponsors working on this as late as yesterday, midday, I guess, and for bringing this amendment forward, because I think this does clarify what I think your intent was in my conversation with Senator Lazzara yesterday, because I think it's important to remember that for out-of-town water users, if you live in town, you're invested. You're not just a customer of water. You're an investor, a shareholder, because your tax dollars have built in most North Carolina municipalities over the last 100, 120 years. You've invested in that. And so I think it's important to recognize those of us who live in towns, in municipalities, have invested in those water systems. So being able to maintain whatever flexibility municipalities have in charging out-of-town rates is helpful. And I think clarifying the public hearing part is important. In my 7 years on city council, I know we'd always have hearings about any change in water rates. So, and I think most municipalities follow that, but codifying that is a helpful step in the transparency of this. So I want to appreciate the work you've done and also acknowledge the importance of municipalities being able to have that flexibility when they need to protect their century-old investments. So thank you all for this amendment.
Senator Perry.
Thank you, Senator Woodard. Members, I do want to just put on your radar, if you were to do any investigation into our water systems and you look at published coverage ratios, the ratio will tell you what the health of the utility is in terms of the revenue and the expense. And anything under a 1, that means it's not covering the expense of the utility. It's not charging enough. I do believe in the future we need to take a look at that, and we need to look at more standardization, including municipalities, on how we approach it, the definitions of different categories, because when you don't have the political will to cover that debt service and the depreciation in the future, thinking about what investment you're going to have to make, you keep your rates low, but you're setting up a ticking time bomb that ultimately ends up becoming a burden on the state. Sure, it's backed by the full faith and credit of the municipality, but as we lose population in certain areas and they don't have enough users, utilities are all about density of users. You got to have enough people cobbled together. That's why we push regionalization. That's why we talked about viable utility reserves. But utilities are supposed to be funded by user fees, not tax dollars, user fees. So there is heartburn around the state about double rates being charged outside of a municipal boundary because the boundary doesn't have anything to do with the utility. And that rate continues forever long after you've satisfied the capital expenditure or the tap that took place in that charge. So it's something that needs more attention. We all agree with municipalities that the concept of the user should pay for it, right? And if you tap on and you cause additional expenses, you should be charged for that, but not in perpetuity on a rate basis. So there'll be more attention we need to pay over this. It's a big problem in the state, but we appreciate your attention on it.
Thank you, Senator Perry. Any further questions or comments? Senator Proctor?
Yeah, Madam Chair, I regret to, I guess, not agree with the intent on this bill. I don't think we ought to be involved in setting the rates that municipalities charge for their water service. There are so many contracts across the state for varying services, including installation, maintenance, meter service fees. And I don't think we should be passing a bill that restricts that or requires a public forum to explain why. There are many rates out there now, as much as 100%. The recipient agrees to pay that price. I know there's a certain amount of clarity that can justify some of this, but I don't think we ought to be involved in setting rates. And I've been asked by a major municipality to object to this bill for valid reasons. When they have all kind of agreements. They have there are 8 municipalities in Catawba County, for example. City of Hickory has agreements with each of these municipalities. They provide most of the water in the whole county. There's different services that they provide to each municipality as far as installation, maintenance. And I don't think you can pass a bill that's going to cover all these off of it. And I don't think we should be doing it.
Senator Perry, would you like to respond?
Thank you, Madam Chair. Senator Proctor, I would encourage them to reread this bill. Nowhere in this legislation do we set rates. Nowhere do we say they can't have a rate they want. We just say, you know, if you're going to have a big change like that in the future, greater than those dollar amounts, you do need to communicate with people, your citizens, your voters, and inform them as to why. That's all it says. They can still do whatever they want to. It doesn't change anything they have in place today. It does not set rates. So I think maybe they just need a deeper read on it or some conversation, and I'm happy to do that.
Senator Perry,
Follow up.
I understand your position on that, but why are we making municipalities have a public forum I guess make public all the charges and so forth on it? I think that's an unnecessary request on the cities.
Okay, Senator Perry, that's fine.
I think it's difficult to not think that we need to communicate with our residents. But some utilities are regulated and already have to do this publicly. Some are not. So it's a level playing field so that consumers are informed. That's all it is. It's communication, it's information. It's no restriction on here saying they can't charge what they want to charge if they just communicate with people. That's all it is. It's a transparency bill, it's consumer protection, and it's good for residents of North Carolina.
Thank you. Any further questions from the committee? Is there a motion?
Favorable to the amended bill, amended, roll into a new CPS.
Senator Woodard,
Move for favorable to the amended bill, roll into a new PCS, unfavorable to the original bill.
with a re-referral to Senate Finance. Thank you, Senator Woodard. All those in favor of the motion, please say aye. Any opposed, say no. The bill has passed, and we are on to our last bill. Senator Moffitt, Senate Bill 613, Sedimentation Buffer for Trout Waters. And I think you have an amendment as well.
Senator Jackson.
Senator Jackson.
Thank you, Madam Chairman. This amendment, members, will just basically, because this section is also in the Farm Act, but Senator Moffitt's bill was a little different, and this just sort of puts them both the same way and is more correct, I think, as my legal attorneys tell me that. So I ask for your support of the amendment.
Thank you, Senator Jackson. Any questions on the amendment? Senator McGinnis moves to vote on the amendment. All those in favor of the amendment, please say aye. Aye. Any opposed? No. And we're back to the bill.
Thank you, Madam Chair. I would just like a motion for a favorable report on this bill as amended.
Do my job. Who made the motion? The Senator Craven moves to, we'll read the proper, okay. Senator Craven moves that Senate Bill 613 as amended be rolled into a new committee substitute, and that committee substitute be given a favorable report, unfavorable to the original with a re-referral to rules. All in favor of that motion, please say aye. Aye. And any opposed, no. Thank you so much. This meeting is adjourned.
Thank you, Madam Chair.